In our profession, with the right knowledge and experience, the sky's the limit. And whilst we know the letters after your name are an important sign of standards, professionalism and trust, it's not all we're about. We're also focused on furthering our members' careers by giving you access to a community of like-minded professionals, all bound by the same code of ethics. There's newsletters, technical papers, podcasts, and so much more great content to facilitate your CPD. Like hundreds of regular face-to-face meetings and digital events, making it easy to stay on top of industry trends and to network with members all over the country. Our societies mean that whether you're a broker, claims, or underwriting professional, our approach is tailored for you. And with membership, you can work towards chartered status for a place amongst the experts in your field. If you have knowledge to share or want to learn, you can sign up to our e-mentoring platform to connect and exchange ideas and support. And not forgetting the perks. Save on a range of products and services, or access our legal helpline for free confidential advice. Get more from your membership today.
Good morning, everyone. Thank you very much for joining us for today's Professional Focus webinar in partnership with our ever-popular Flaxman partners. I'm Carly Knights, Professional Development Manager at the Chartered Insurance Institute, and it is my pleasure this morning to be introducing this webcast on non-disclosure, avoidance, and the forgotten claim. This is the second session on this topic that's been delivered by Roger and Michael at Flaxman's. If you missed the first one live just before Christmas, this is still available to view on demand and via our society content pages on our CII website. Now, before I hand over to Roger and Michael to introduce themselves, just a couple of things to run through on the housekeeping side. Please do ensure that you're on mute to limit any background noise throughout this presentation. If you have any technical issues, you can find the answers to some common problems located in the help section at the bottom of your screen. Now, your CPD certificate and all supporting documents that Flaxman's have designed ready for you will be available for download once this session is over. Questions are going to be welcomed, so please ask your question using the Q&A section on your screen. We will run through as many of these as possible once the presentation is complete. Finally, please feel free to leave your comments and feedback in the section on screen, or alternatively, you can use the Flaxman Partners Trustpilot page so that they can receive this immediately. We will provide this link in the supporting documents for you as well so that you can access this easily. Thank you very much for your patience with that. Now, without delay, I'm going to hand you over to Roger Flaxman and Michael Wilson.
Good morning and welcome once again. I'm Roger Flaxman, and with me, as usual, is my senior consultant, Michael Wilson, who's no doubt helped a good number of you deliver good news to your client. Their claim is being paid after all. That's what we do. Now, back in November, we addressed a conundrum that repeatedly arises in the cases that we deal with. It concerns what we think might have been an oversight in the drafting of the Insurance Act 2015. If it wasn't an oversight, then, as we said in November, it's our opinion, it's a matter that needs some attention by the industry, because it's a matter that goes to the heart of treating customers fairly and to the root of the integrity of insurance contracts and of our industry. Many of you know this already, but we are pretty much on a continuous campaign to help to improve the value and integrity of contracts of insurance. All we can do in practice is to bring matters to the attention of our audience and make representations to appropriate parties at the appropriate time of opportunities. I had some opportunities yesterday at the BIBA manifesto launch, where there's some MPs who were worth lobbying to. They got a little fee in the area about one or two things. In the end, it is a matter of good faith by our insurers, our industry, our insurance community, whether we adopt practices as fairly. All we can do is to help point out how much it hurts a customer when it. Now, most of you will be aware that the Insurance Act 2015 has a provision applicable to conditions and warranties, whereby if the causation of the loss is not affected by the breach of the condition or the warranty, then the insurer cannot rely upon it to repudiate the claim. However, if the underwriter has not imposed a condition or warranty, but is relied instead, for example, on a statement of fact, then a breach of the thing becomes, in fact, a misrepresentation, in which case it is treated differently from a breach of condition. Now, this takes a bit of getting your head round, and we did explain it in our previous webinar last November, but we're going to go over it again. And just to give you the heads up, this is not a slide, I'm just going to read this out because it's a lot quicker and easier. What the Act says at section 11, it says terms not relevant to the actual loss. And it says this section applies to a term, whether express or implied, other than a defining term, if compliance with it would tend to reduce the risk of one or more of the following: a loss of a particular kind, a loss at a particular location, or a loss at a particular. Then it goes on to say, if a loss occurs and the term has not been complied with, the insurer may not rely upon the non-compliant, exclude, limit, or discharge its liability, the loss, if the insured satisfies subsection 3. And subsection 3 says, the insured satisfies this subsection. It shows the non-compliance, that term, could not have increased the risk of the loss which actually occurred in the circumstances in which it occurred. Now, the best thing to do with that, if you're not familiar with it, is go and look it up and read it 2 or 3 times. It actually is quite well written, it is quite clear, and it is being used and adopted, to my knowledge, by most loss adjusters and lawyers quite reasonably. However, what we're going to do today is we're going to give you some examples of how that's applied in practice, and then we're going to move on to other aspects of misrepresentation as distinct from breaches of contract terms, and how we believe these issues of misrepresentation be dealt with. Now, these include undeclared past claims, other matters where applications for insurance have gone wrong because the the proposer has been wrong-footed or simply doesn't understand the questions that have been asked. And now this situation isn't new, by the way. The Financial Ombudsman back in the 90s recognized this problem, and we'll come back to that later, but I think now's a good time to review it. So that's what we're going to do today. And before I ask Mike to come in, I'd just like to give you a point of reference and reassurance in what we are saying. We at Flaxman are probably in a unique position to feed back to our industry the things that can go wrong in insurance claims, and so cause our reputation to be tarnished in the eyes of the public, and of course in the eyes of the media, who love to push bad news. By definition, the insurers in particular will be sensitive to criticism, which is implied by the issues that we raise. But we want to say this. In some 20-odd years of dealing with insurance disputes on behalf of brokers and policyholders, we have had remarkably few serious disagreements with very few insurers. Mostly, the insurers are delighted that we've taken a professional and proactive approach to what we refer to as closing the gap. And in the majority of cases, they've readily agreed to reconsider a claim decision, which is the whole point of the thing. And we've done that. It's been a win-win. Let's put it this way, because we've done it without having to sue anybody for a decision. And it is remarkably cost and time efficient. So let me just say this. We don't encourage or support complainant policyholders that have failed to be open and honest with insurers. We don't tolerate that. Neither do we take on cases where we know or we believe that the insurer is right and they have a good point in their decision. Because there are always two sides to the story, and fair treatment goes both ways. Neither are we suggesting, and particularly today, we're not suggesting that insurers should be hamstrung in their rights and remedies to uphold the principles of good insurance, because that would simply be foolish in the extreme. But where there are examples of clearly bad practice, bad faith, or simply things just don't work the way that they really should, then we think it's good practice to say so to the community and let the community decide. And that's what we're doing today. So now I'd like to hand you over to Michael to take you on today's journey. Michael.
Well, thank you for that introduction, Roger. I should just go through today's learning objectives before we go any further. So it's to review the basis on which a policy of insurance may be avoided by the insurer for misrepresentation, to review the protection afforded the policyholder and circumstances where a policy may not be avoided, to contrast the respective disclosure regimes for businesses and consumers, and to discuss the difficulties posed where a notification relates to past claims, past insolvencies, criminal convictions, and other information available to the insurer. Now, just as a reminder, the general principle is that non-disclosure can lead to the avoidance of the policy. In other words, the policy would be treated as if it had never existed in the first place. Now, the existing legislation does provide some protection for the policyholder. Under the Insurance Act and the Consumer Insurance Act, there is some protection. And the question that needs to be posed by all concerned to establish whether or not there's an opportunity for the policy to be avoided is, to what extent did the non-disclosure induce the insurer into entering into a contract of insurance that otherwise they wouldn't? That's the general question. But also, under the Consumer Insurance Act, there is a further protection for the policyholder, and that is that before an insurer can seek to avoid a policy for misrepresentation, the insurer must be able to show that the insured has at least been careless. And therefore, if an insured can show that they have taken reasonable care in answering a question, but nevertheless has got it wrong, that is not a qualifying breach under the Act, and so therefore the policy cannot be voided, and therefore the claim must be paid.
Now, Michael, just to be very clear before we move on from that, that is a very important distinction to be made between the consumer law and the commercial law, isn't it?
And we find it's often overlooked.
Very
so
often overlooked.
It's a good reminder that there is that extra protection for the consumer policyholder. So we're posing this question. That's why there's a question mark after new code of practice. We're suggesting that maybe we should further limit the insurer's right to avoid a policy in circumstances where a non-disclosure has not been causative of an underlying claim. And this is the area that we covered in our previous seminar. And I'll just run through one of the examples that we looked at last time. And it's this one here, where a public liability insurer wants to avoid any claims connected with the application of heat. And the insurer has a choice as to how he tackles this. He can either include the matter in a question or a statement on the statement of fact, or the insurer can impose a conditional warranty to that effect in the policy. And to highlight the apparent unfairness, we quoted an example of a painter and decorator who, in the course of a contract, spilt some paint on a carpet. And there was a third-party claim as a result. And during the investigation of the claim, it was revealed that this decorator did, from time to time, use a blowtorch. Did that impact on coverage? Well, if the insurer had taken the first route and included the issue in a statement of fact, and assuming that the policyholder had failed to disclose or correct the question to disclose the fact that he does sometimes use a blowtorch, that would be a material misrepresentation, and the insurer would be entitled to void the policy and not pay the claim. However, in identical circumstances, had the insurer chosen to deal with the issue by conditional warranty in the policy itself, then the insured would have the option to demonstrate that the apparent breach of the condition had nothing at all to do with the circumstances of the claim, in which case the policy remains in force and the claim would have to be paid. So we just feel that this is a good way of highlighting the unfairness that can exist, where an insurer has an opportunity to void a policy through misrepresentation, where there's no connection with the claim that gave rise to that inquiry. And you may also remember that we had another case, the house on the hill. This was a consumer case where the proposer had failed to disclose the fact that the property was within 200 meters of a watercourse. In fact, it was only 180 meters. And when the property suffered from a flood and the claim was investigated, it became apparent that the property was within 200 meters, and so therefore the question on the statement of fact was wrong. You might feel that it's only fair and reasonable, therefore, that the insurer should void the policy for misrepresentation. But it wasn't as simple as that, because it turned out that the property was a long way up a hill. The actual flood that gave rise to the claim was because of a blocked culvert further up the hill. And even the loss adjuster expressed the opinion that this property could never, under any circumstances, ever be flooded by the river that was within 180 meters. But nevertheless, the insurer chose to void the policy and would not pay the claim. And so that's another example where we call it an anomaly. It doesn't really sit very well. So that's the area that we covered in the previous webinar. Roger, do you want to introduce our second proposal?
Yes. What we're concerned about here is the misrepresentation, in particular, because of people who have failed to understand the questions that are being asked in the proposal, or they failed to notify claims which they've simply forgotten about in the past. And these are issues that come up time and time again. So, Mike, would you like to give some examples of how that works in practice?
Yes, well, I've got an example here to do with motor insurance. So we had an applicant for insurance who had 3 previous claims within the last 5 years. And an accident in the previous year had been correctly disclosed, but the insured had overlooked an earlier claim. And following another accident, the insurer investigated or interrogated the claims and underwriting exchange, which brought to light that there'd been a non-disclosure of an earlier claim. So on the face of it, the insurer would have the right to void the policy and not deal with the claim. Now, as it happens in this case, there had been a misanalysis of the dates, because it was a case where the insurer would have accepted 2 previous claims, but not 3. And on analysis, it turned out that the older claim was just outside the 5-year period, in fact. And the claims and underwriting exchange data had to be corrected. So in the end, there wasn't a problem. But it's an interesting issue to look at. Is it right that an insurer has the opportunity to void a policy where there's been an innocent oversight of a previous claim? And we look at this again a little bit later on. So I'll leave that question open, and you could be reflecting on whether or not you feel that that's a fair option for the insurer to take. Roger.
Well, now the next issue is, as I just mentioned, the question of failing to appreciate the meaning of a question. And one of the things that is often said to us by our clients is, we just didn't understand what the insurer was getting at. Now, there's lots of examples in this area, and we're going to go through some of them. But the fundamental point is this, that one of the changes, I think one of the fundamental changes in our industry in the last, say, 10, 15 years has been the reluctance of the industry to ask questions and to rely instead on simple statements of fact or disclosure since 2015 on reasonable presentation of risk. It's all very well, but I'm saying this, we are saying this, that from where we sit, we think that the objectives in the mind of the architects of the 2015 Act were to balance up the fairness of the contract of insurance. And part of that, surely, is to turn the proposer's mind to the things that a prudent underwriter has in their mind. Now, speaking personally, I've been in the business over 50 years, and I do understand the subject, and I do know how insurance works, but I don't presume to know, even now, what is necessarily in the mind of a prudent underwriter. And as a person who has to go into court every now and again and be cross-examined, one of the things that I'm often asked is, Mr. Flaxman, how do you come to that conclusion? And I have to have a reason for it. And one of the things that I can never say is that an underwriter would have, because I'm not an underwriter. I was a broker. How can I know, how can anybody know what another person has in their mind? But the whole of the premise of insurance is to ask the proposer, who's got no more idea about insurance than I have about brain surgery or rocket science or anything else. And we're asking him questions that would induce or affect the mind of an underwriter. So what we're really saying is that it is going to be important, one way or another, to find a way of directing the mind of the proposer to the mind of what the underwriter really wants to know. So, Mike, would you like to take us on to the next part? Just to illustrate.
Yes, I've got another example here. I've got a couple of examples here which can take a proposer for insurance by surprise and possibly even lay a bit of a trap for them. So this example here is somebody who's been charged with a serious offence just before the renewal of his home insurance. And the broker has explained the disclosure requirement as I've shown here on the slide. But the problem here is that although this was a very serious offence that the person's been charged with, he's only been charged, he hasn't yet come to trial. So it's a pending charge. And had it not been for the broker, it would never have occurred to him that that was something that he would have to disclose. We all know that proposers need to be directed to the statement of fact to consider the questions carefully, but a lot of proposers don't. And I would estimate that 9 times out of 10, somebody who's been charged with an offence but not yet come to trial would assume that that would not be of any interest to anybody, if only because he'd be entitled to some protection because of the presumption of innocence until proven guilty. In fact, he would probably feel it's a major breach of his rights to be expected to disclose something like that. Now, what actually happened in this case is that because under the Consumer Act, a proposer is only required to answer the questions that are posed, he was able to find another insurer who didn't ask about pending convictions, and he was able to get the cover. And he was relieved at that, because what the proposer didn't want to do would be to disclose the pending conviction, then find that his insurance application was declined, because that would double up his problem, because now he would have to disclose the pending conviction and also the fact that he'd had a proposal declined. So we're just raising this as a question. First of all, yes, it's a trap that a lot of people would fall into. And we should also bear in mind that people who have got a pending charge can be waiting for 2 or 3 years before very much happens. Is it fair and reasonable to ask the question? And is it a requirement possibly on the part of the insurance industry to take that into account and perhaps standardise the approach? Because I don't find it very edifying, the thought of a proposer going from insurer to insurer until he finds a statement of fact that's got just the right questions that suit him. It just doesn't sit right. Now, I appreciate there's a moral hazard issue here, but we're just flagging this up as a discussion point. Another common problem relates to past insolvencies. And the example here is that Mr. C is a chair of a management company of the block of flats where he lives. Now, if you look at any block of flats in this country, there's a possibility that there's a limited company which has been formed to act as the management company to represent the interests of all the leaseholders. And so there are thousands of these small limited companies up and down the country. But of course, when it comes to looking at a statement of fact when proposing for insurance, you would normally expect there to be a question about past insolvencies. And in this case, following a small fire, it was revealed that one of the company directors had previously been a director of another company that had gone into liquidation. Now, this hadn't been disclosed. And in fact, in the particular case here, the insurer accepted that had he known about the insolvency or the past insolvency of that company, they would still have accepted the risk. So in the end, the claim was paid and the policy remained intact. But it came as a shock to the policyholder and to some extent to his broker that this was a potential problem. And of course, if you read carefully the words of this, and it'll be in our fact sheet, it does raise the question as to whether the liquidation needed to have been declared in the first place, because it's a very imprecise and not terribly well worded statement in the statement of fact. And the other issue,
Mike, I think Mike, it would be worth making the point here that in looking at this issue, we've studied dozens of these questions, and the thing that worries us is that they're all different questions. They're all purporting to ask the same thing. But this, of course, was one of the things that came out in the FCA litigation, with the disease clause. There were umpteen variations of what appeared to be exactly the same thing. And if, as an industry, we want to rekindle the trust of the insuring public, we really ought to be standardizing the things that really matter most to the industry. If we want to find out about insolvencies, bankruptcies, let's find a form of words that we always ask, and they're always common. That's the point we're making here, isn't it?
Yes, and in fact, there is some case law that addresses this issue of the precise wording of these insolvency questions. And in some cases, such as this one, a court would probably say it's a limiting question, in that it doesn't quite ask the right questions, and so therefore it might, under certain circumstances, relieve the policyholder from having to disclose issues that go beyond the actual type wording of that clause. But we're going to address this on a future occasion, because it's a big issue, and we see a lot of it. I think for now, the message I would just want to put across is how many directors of a management company like this would even think about speaking to their fellow residents who happen to be directors of the company about past insolvency and, for that matter, criminal convictions. It's not the sort of embarrassing conversation you would have over your gin and tonic after the AGM. And I'm not too sure that brokers generally would flag it up as being a danger, because it just doesn't figure. Because if you're insuring a business, a factory, for instance, you would probably think a little bit more about these things. But the question of past insolvencies on a risk such as this just does seem a little bit obscure. And you're quite right, Roger. Perhaps we need to be looking at ways of standardising.
Well, just by way of another example, we had to deal with a care home recently where the care home had been in the same family for about 25 years. And over that time, various other members of the family had run other businesses, nothing to do with care homes. One was to do with laundrettes, and I think another one was catering. And several of these businesses had actually been wound up over a number of years. They were wound up usually because members of the family moved, or the business wasn't doing too well. There was nothing sinister about it. There were no sort of bankruptcies or anything like that. But the insurer, when they found out that other members of the family had, if you like, suffered the ignominy of winding up a business, they said, well, we're avoiding the policy for non-disclosure. And again, Mike and I have been in this business a long time, and we cannot for the life of us fathom out what the relevance of that is to the risk of insuring the care home, which actually was quite solvent and quite safe and quite well run, just had a bad fire. And these are the things that I think that we want to bring to the attention of our listeners, our audience, because they really matter to our insuring public.
Yeah.
What are we really trying to do?
Our first proposal to the industry about having a new code of practice in relation to non-disclosures which are not relevant to the loss doesn't mean that we're taking a soft line on all misrepresentation. Far from it.
No, not at all.
A couple of slides here which show the different types of misrepresentation. Could you just run through those for us, Roger?
Yes, just to make this clear, we've put this together. We haven't got this out of a textbook, and it's not a sort of a legal doctrine. But what we've done, just for the sake of illustrating it, to make our point, is that there are, in principle, two types of misrepresentations. The ones that you can see on the slide here are things that all of us would know are, if you like, peculiar to a risk. And like proximity to a watercourse comes up time and time again. The fundamental issue is that if the watercourse, as in the case we said in the house on the hill, if it couldn't possibly have flooded the home, well, the fact that it was there, why would an insurer want to take that point? If a car modification is made and it has absolutely no bearing on the loss, why would you want to take the point? Why would you want to say no to paying a claim when you don't have to? Because that's the public's question. That's what they ask us. Why do they want to do this? And the answer is very often, and it's been said there at times, because we can. The other type of misrepresentation actually goes what we call to the heart of the risk. Past claims, insolvencies, convictions, all of those things, you could say they are, if you like, omnipresent in the risk. And they're not suggesting that our, if you like, more lenient attitude towards misrepresentation should necessarily apply equally to type 1 and to type 2. It's open for discussion. And above all, when we're sitting and looking at these things, we look at them actually, first of all, as though we're pretending we're the FOS or, we're an ombudsman. What's the fair thing to do? And very often we can find a fair way through, which is where we say to the insurer, well, look, actually, you can look at it like this, you can look at it like that. Can we close the gap? And very often they say, yes, we can. And so we want to make very clear that what we're suggesting in our, if you like, campaign, our proposal here, that we could find a code of conduct with regard to how we deal with misrepresentation, which is a little bit more akin to what the Act says about the conditions and warranties. Bring those two slightly. What we're saying is we do not have any intention of wanting to say, let's emasculate the insurers from being able to do anything at all. That is not our case. So, Mike, why don't we go back and have a look at what I referred to in my introduction about what the Ombudsman of the Bureau said back in 1996.
Yes, this was before the Financial Ombudsman Service came into being, so it was the Insurance Ombudsman Bureau. And I was doing some research for the previous webinar and came across some very helpful comments that Laurie Slade made when he was the Principal Ombudsman in an annual review in 1996. So we quoted a passage from that report in the last webinar, but I came across another one which brings us back to the issue of the forgotten claim, the policyholder who's innocently forgot to notify at the proposal stage that he'd had a previous claim. And this is what Laurie Slade said in 1996. He said, the object of the claims and underwriting exchange, in other words, Q, is to provide insurers with a comprehensive register of claims made by policyholders as a way of reducing fraud. The question is, at what point should Q's database be accessed by the insurer? Statistics have been published by some of the household insurers showing significant non-disclosure by policyholders of previous claims experience at the time of proposal. This information is available at the time of proposal. It would obviously be helpful in identifying the fraudulent applicants, but it could also identify those who have genuinely misunderstood the questions that they have been asked, or the nature of the information they are required to provide. If an insurer chooses not to access Q at the time of proposal and leaves it until the time that a claim is made, I may well consider it has waived the requirement for disclosure of matters covered by Q, where there has been an unintentional representation by the policyholder. Such an approach seems an inevitable consequence on our insistence that underwriting must be done at the time of proposal, not at the time a claim is submitted. And we made a similar comment in our previous webinar that this common sense statement or comment was made 25 years ago, and we find ourselves even now discussing the same issues. And of course, technology has advanced to the stage that for an insurer to interrogate Q is a fairly straightforward matter, possibly done just as easily at inception as at the claim stage. I should just remind people here that Q doesn't cover all insurance. Q is primarily related to consumer insurances, but it also extends to all motor insurance and some personal injury and industrial injury matters. So it's quite limited. But even if we just apply this to the consumer, it would make a big difference if our proposal that that reflects what Laurie Slade has said, we think that would be quite reasonable. And in actual fact, for future discussion, we might also like to include the fact that when it comes to disclosure, if an applicant for household insurance, when he discloses his postcode, to what extent should we think it's fair and reasonable that the insurer should be able to work out for himself whether or not that property is a flood risk. And we also had a recent problem with some travel insurance, where the policy promised emergency medical treatment, but that treatment was held up at the claim stage because the insurer was wanting to check the GP record to see if there'd been a non-disclosure of a pre-existing medical condition. So here we had an insurer who chose a very light touch underwriting process, but the emergency claim was held up while those inquiries were being made. Is that reasonable? We haven't really got time to address that now, but that's something, again, for the future.
But Mike, I would like just to add this. So again, going back to my position of regularly having to deal with these things in court, I can tell you that the judiciary are getting very fed up with underwriting after the event. I mean, I'm dealing with a case at the moment where it's a fundamental issue, and there's some really, there's some strong views about it, because the view being expressed is that in an age of technology and at a time when the industry is frankly replete, if not almost drowned, with innovative technology to reduce the frictional cost of buying insurance. On the other side of the fence, where the legal profession see it, is, well, if you've got all that technology and that time, why don't you underwrite before you agree the contract? That's the question. Now, it's a big debate, but let's move on to what in fact, the Insurance Act has said, what Laurie Slay said. You could say, if you look at this, it says, in the absence of inquiry, subsection 4 does not require the insured to disclose a circumstance if it diminishes the risk, the insurer knows it, the insurer ought to know it, the insurer is presumed to know it, or it's something as to which the insurer waives information. Isn't that what Laurie Slade said? And what we're doing is bringing these things together, because what we're saying is that the Act, as we've said before in our previous webinars, actually we think it was a good piece of legislation. We're now, 6 years afterwards, we're finding some wrinkles in it. They're not that substantial, but there are wrinkles in it, and we just exposed one today. And wouldn't it be sensible, if you look at what you have in front of you there in the Act, and what Laurie Slade has said, is to start closing that gap and see if we can actually make that a little bit tighter, because that is what will improve our reputation.
That's it precisely, Roger. And we're coming to the end, so we've covered a lot of ground here. So just want to summarise where we're up to. So we're suggesting that the industry could consider adopting a code of practice to apply to the following two issues. One is misrepresentation, where the information withheld is not causative of an underlying claim. And secondly, to cover misrepresentation where an insured has failed to disclose a previous claim, where the insurer already has access to that information on cue. And then the other issue that we've covered is possibly for the industry to consider the implications of questions and declarations that the insured finds confusing or unexpected. For example, the matters associated with prior insolvencies and the block of flats and possibly pending convictions. Now, we have covered a lot of ground here. We look forward to tackling one or two of your questions, but all attendees today will be provided with our fact sheet, which we've produced in conjunction with the CII, and that covers all the ground. So some of it's very technical, some of it's quite detailed. So we do encourage you to take the fact sheet, read it through at leisure, and then you're more than welcome to come back to us and make any further points. And also, all of you will be invited to attend a future discussion forum so that we can have an open discussion about this. Because Roger and I have got to recognise that we mustn't be like the GP who thinks everybody's ill, just because everybody who comes to see him has got a medical condition. So likewise, we mustn't assume that just because we only see the problems that there's no such thing as a successful and fair claim settlement. We're not saying that at all.
So
but
we know there is.
Yeah. So and in particular, we would like to hear from insurers who are already following the principles of what we've covered here, without the need for any change in the law or without any need for codes of conduct. We'd like to hear examples of good practice. So with that, I think we're back to Carly with any questions.
Great. Thank you very much, both of you. As usual, excellent and full of information. You have had quite a lot of questions come through, so let's see what we can get through in the next 15 minutes. And then for anyone who wants to stay on beyond the 12 o'clock, Roger and Michael are more than happy to hang about for a few more minutes to answer some more. So I'm going to start right at the very beginning, the questions that started to come through in the first few slides. So the first question for you both is, does the consumer law apply irrespective of PH size?
Yes.
Excellent. Simple, to the point. Okay. Right, so what is the situation if the matter is referenced in the SOF and then attached as a warranty or condition?
Could you read that again?
Sure. What is the situation if the matter is referenced in the SOF and then attached as a warranty or condition?
If it's, in other words, if it's in both. That's what you're saying, isn't it?
Yeah.
Well,
I think Roger,
that's very. Go on, Mike. You do it. You do it.
Well, I was going to say the answer to that is we don't know because we haven't come across it yet, where it's covered by both. My inclination would be to say that the conditional warranty is the more specific, and so I would be inclined to assert that the success or otherwise of the claim should be based on whether or not the warranty is relevant. But yeah, I can see an insurer equally arguing that if the statement of fact is wrong, because that goes to the root of the contract, that should trump the warranty issue.
I think it's one of those cases, Mike, that if we were to look at that, we would spend quite a lot of time looking behind the scenes as what the contract was all about, what was disclosed, what the underwriter was. There's lots of things you can go into. It's not a tick box answer, but it's a very good question. And it's the kind of thing we could discuss in a forum and come up. And if you come up with a real good example of one, we could say, okay, well, this is what to look at. This is how we come to the decision. And you may or may not agree with that decision. But what we would do is put a reasoned decision as to why we thought it was the SOF statement of fact or why it was the condition. And we'd come up with an answer. But it's a very good question, though. Thank you.
Great, thank you very much. Okay, looking at statement of facts, this delegate has said, I'm aware of a situation where an insurer has stated that an IVA, so debt arrangement, even if not asked for within the SOF, remains a material fact and must be disclosed. Are you able to discuss this?
I think on prima facie, I would say it probably is material information, because I think it goes to the root of a risk. Mike, what do you think?
I'm assuming this is not a commercial contract, not a consumer contract, but a commercial contract. I would want to look exactly at the way that the statement of fact has been framed, because you might get to a similar situation where you had on the example that we had on the slide, where if the insured has answered the question in relation to the specific question that was posed, then the view could be taken that the insurer, in posing the question in that exact way, has set out what he wants to know. And therefore, it's another example of what the courts might refer to as being a limiting question. And if it's a limiting question, it can act in the way of waiving the insurer's right to want to know about associated information that goes beyond the specific question that's been posed. So it's very fact specific, and we would want to analyse that statement of fact in some detail to form a view.
But it's a very good example of what we were saying earlier, isn't it?
It is.
Very good example. Well done.
Great, thank you very much. Okay, slightly longer one for you both. So, if we standardise insolvency wordings on statement of facts, there is a risk that this would restrict acceptability. At present, some won't accept and others might, depending on the circumstances. A broker can therefore seek out the insurers who uses a wording that accepts their client's situation. So basically, will standardisation restrict access to insurance?
Well,
Roger, can I respond? Sorry, can I respond to that to begin with? Because
yes, sure, yeah.
I've come across this, and that broker's strategy, the success rests on being able to establish that if an insurer asks a restricted list of questions to do with insolvencies, that in fact it has waived its rights to want to know anything else. Now that to me is a very risky strategy, because you don't know until it's tested in the courts whether or not that's going to stand up. So I'm not entirely sure that it's the best way of getting the insurance. And the reason I think that it would be better to have a standardized approach is that at least everybody knows what's expected of them. And then maybe arising out of that, it would be reasonable to have an open discussion with the industry as to what insolvency events in the past really are material to the risk. Now, this is very difficult when you're looking at matters of moral hazard. But just because somebody has had an insolvency doesn't mean that there's a problem with moral hazard, or that they're necessarily going to repeat the same pattern. Neither is it necessarily an indication that we're talking of a Phoenix company, which has cynically arisen out of the ashes of a previous company that's left many, many creditors themselves becoming bankrupt because they haven't had their bills paid. So it's a murky area, but I think seeking the statement of fact that suits your client's circumstances the best is not necessarily going to succeed.
No. I think when it comes to the question of acceptability, in my experience, the market that we have in this country at the moment is usually wide enough and deep enough that there are people who will say, we understand this and we're prepared to take on the risk. And having been a broker for over 30 years, I used to know the underwriters that knew what they were talking about and wanted genuinely to get involved and do the right thing. You know, you just know you've got relationships with insurers, and you would say, if an insurer says, oh, I'm not sure if I can accept this, then actually is he the right person to place the business with, except on price, you know, it's always the determining factor. So I think that the question, again, is a very good one. I think Mike's answer is spot on. And I think when it comes down to would it restrict the market, I think that's the least of our worries. Because if you get the questions right, if the questions go to the heart of what the root of the problem is, then acceptability problems go away.
Thank you very much. Next question. Is there any recourse to an insured who has had their policy voided for non-disclosure of past insolvency?
Is there any recourse to an insured who've had their policy
voided for non-disclosure?
I'm just trying to work out what the question is. Recourse.
Yeah, I'm not
if
too sure I
understand. Do you understand it, Mike?
If it's a consumer contract, then it's all a matter of was there a question on the statement of fact? If it's and of course the insurer would also have to demonstrate that the insured had failed to take reasonable care. But other than to remark on that, I'm not too sure what the question is getting at. So perhaps that's something.
So you're saying recourse to the insured. Do you mean recourse by the insured? I'm sorry, but I just don't quite understand what the questioner is trying to ask. So
well,
if you'd like to ask it again.
Let's come back to that.
Come back to it, yes.
We can come back to that. If that delegate would like to resubmit that question, we'll get back to that one. and see if we can answer it for you. Thank you. Okay, next question we have is, misreps are classified as innocent or deliberate or reckless. Are you only considering innocent? Now, if so, what proportion of misreps you see are avoided on basis of deliberate or reckless?
If we see a deliberate misrep or reckless, and we do see them, there's not much really we want to say. In fact, we came across one recently. It was in a building contracting company, and we looked at it and we thought, well, he was just trying to cheat the insurers, and there's not much to say. So what we're talking about is where the misrepresentation is not deliberate, not reckless, but borders possibly on careless, but fundamentally was innocent. In other words, it was without any malicious intent. I mean, that's right, isn't it?
The only thing to add is that under the Insurance Act for commercial policies, the only relevance, as the law stands, between innocent and reckless and deliberate is whether or not you get your premium back if the policy is voided.
Yeah.
Whereas, of course, we tend to focus under the Consumer Act for consumer policies on whether or not the insurer has even passed the first test of showing that there's been a lack of reasonable care. But the rest is less important.
We do see cases of reckless and deliberate misrep, and funnily enough, they come to us for help, assuming they're going to pull the wool over our eyes. Well, they don't, because if you've been in the business for a while, it's as plain as a pike staff would see it usually. And
Roger, although in your opening comments you made it quite clear that we are not here to defend policyholders who do these things deliberately, and so any proposals that we have must be focused on those policyholders who are in effect caught up in an innocent non-disclosure.
Yes. And
I think anything beyond that wouldn't be covered by the issues that we're proposing today.
No, not at all, no.
Great. Thank you very much. Okay. We have a lot of questions still coming in. So could you give an example of a justified non-disclosure by the insurer, please?
A justified non-disclosure, isn't that an oxymoron? Mike, what do you think? Justified non-disclosure.
I don't believe there's any such thing.
No, nor do I.
So looking at a consumer insurance, they need to pay attention to the statement of fact and answer the questions openly and honestly. You could say, if you wanted me to find a justified non-disclosure, it might be a case where it's information that's wrong, but the insurer was not aware of it. And so therefore, the insurer could not show that the insured had failed to take reasonable care. So
but on that basis, it's not justified because they didn't know it, so they couldn't justify it.
Yes, exactly. I'm trying to stretch your point here, I suppose.
I tell you what, Mike, we can go back. We can go back to what you were saying earlier, which is about the charge, before conviction. You could argue that it's justified. You could argue that it's justified in English common law not to be required to disclose something about a conviction or a pending conviction until you've been convicted. Now, I know that that's debatable. I understand why it's debatable, but you could argue that that is an example of a justified non-disclosure, because until the industry can assert that it is entitled to effectively predetermine the outcome of a court of law, which a court of law wouldn't like it to do, you could argue that's the situation. Similarly, is another thing that leads on to, which I think we've talked about in the previous webinar, is the insurance industry puts people on the fraud register without proof of fraud. Now, all of these things are getting into very, very sensitive areas of discussion. That isn't the case, an example of a justified non-disclosure. But looking at it from another way, you can understand how a member of the public says, this situation is sufficiently private to me, I don't think I need to disclose it because I don't understand why I should. And that comes back to what we were saying about the questions. And funnily enough, one of those, that issue has come up in our recent past on 2 occasions on medical matters with travel insurance. There's been a lot more travel insurance claims that come to us since COVID. And some of them are repatriation issues. And the questions that have been asked after the event about health, not only of the insured, but also of their relatives. And the insured and their close relatives say, well, what's that got to do with it? Oh, well, if we'd known that, we would have wanted to know. We might not have written the list. And this is because, you know, sort of distant relatives having various pre-existing conditions. Now, this is the kind of thing that, so it's a very good question you've raised, because actually, well, look what we've been able to say about it. Fundamentally, it's an oxymoron to say that there is a justification for non-disclosure. That doesn't work. The real question is, what is disclosure in the context of a reasonable and a fair and reasonable representation of the risk, and where are those boundaries? And that's what we're getting into here, isn't it?
Great, thank you. That was a pretty good answer for a question you weren't sure about. Okay. Is there a period when an insured does not have to disclose previous insolvencies? So, for example, over 20 years with no issue since?
Depends who you ask. That's the problem.
Okay,
So
right.
The answer is no, because it depends. I mean, some insurers will say yes, some will say no. This is the problem. We don't have a standardized agreement. And so, again, it's a very good question. In fact, if you look at the Rehabilitation of Offenders Act, and use that as a basis or the principle, then what you could argue is that we could either have a code of conduct or even go towards some kind of legislation on the basis of what is disclosable in civil matters, because that's what we're talking about. What's the equivalent? And the fact is that in this country, we've still got the ignominy over insolvency and bankruptcy. A lot of other countries, they just say, oh, it just happens, get on with it. So we're actually making a moral hazard out of something that other countries don't make a moral hazard out of. And I was doing some cases in India a while ago, and they don't make a moral hazard out of insolvency, bankruptcy, because they do it every day. So these are relative things. These are, you know, we're working in a worldwide environment. You know, we've got every possible variation and theme of variation in this community, and our insurance industry is dealing with the lot. So I think, again, it's a very interesting point and kind of thing that would be wonderful to have a 15-minute session on in our forthcoming forum, if somebody'd like to.
Roger, I would just like to add 2 things. First of all, I think we would need to highlight the misery caused by the Phoenix type operation, where directors lead a trail of devastation behind them, a lot of unpaid creditors. They start another company, and then they do the same 2 or 3 years later. I don't think the insurance industry would want to take a soft line on that. But I think coming back to how many years back is it really necessary to go, I think I'm not disagreeing with what you say, Roger, but what I would say is if it comes to a claim that makes the underwriter examine whether or not information was withheld, it makes it more difficult. The longer ago the previous liquidation was, the more difficult it would make that insurer or that insurer's job of showing that he would not have accepted the risk had he known.
Well, let's put it like this. If we take a case, let's just say it was 20 years ago, and somebody, you know, did something naughty. It's not the time that matters so much. It's the specific facts of what happened. And if somebody had a criminal mind and intent 20 years ago, it's not unreasonable for an underwriter to say it probably pertained to the next 20 years. Yeah. So this is why I'm reluctant to say it's a time factor, because time isn't necessarily the thing. It's actually what was the circumstances. Was it innocent? Was it just business? Was it just a commercial thing? Or was there something about it that, had the underwriter known, however long ago it was, he'd have said, I don't want to be involved with this. That's the difference. So my instinct is to say, I'm not sure if time is going to help us. But again, it's a debate to be had, isn't it?
Well, it's a debate you've got to have, particularly if you're having to make a fair presentation and there's no proposal or statement of fact.
Well, that's the point. That's the point. That's the point. So if we said that actually we want questions which are clear, then see, the underwriter might say, well, if I leave it open, then I can always go back. I've got a platform for refusal later. If I say I want to know anything within 20 years and it happens to be 21, I'm missing out. Well, if that's the case, don't underwrite the risk. Don't take the risk on. But I think that some degree of you remember, we used to use this expression back in the, 80s or 90s or whatever it was. I can't remember when it came in now. I think as long as that. Contract certainty, which has got nothing to do with what we're talking about, but it's an expression which was brought in when regulators started to say, let's get some certainty into insurance contracts. And you know what? I fundamentally believe that we should. And that certainty, every lawyer listening to this will say this, will agree with me on this, I'm sure. That certainty starts with the proposal. If you don't ask questions up front, you can't expect somebody after to say, well, I didn't know you needed to know that. And this is why I think proposal forms should be reintroduced. I know that they're frictional costs and I know all the problems, but if you think about how much in data we can capture in a second now, no time at all, we can capture it so easily, whereas 25 years ago we couldn't. But we were doing it with proposal forms. It's gone topsy-turvy, isn't it? Now we've got the ability, we've chosen not to do it. Curious. Sorry, going on a bit
Thank
there,
you.
but it's a big topic. It's a big issue.
Okay, right. Let's go back to the questions. So, next one. If a commercial policyholder has an exceptionally large claim, i.e. 2 million, but it's over 5 years ago, would they still be expected to disclose this as a material fact to another insurer, even if it is over 5 years ago?
I think that's material because of its size. I can't think of any good reason why they shouldn't. My question is, why would they not want to? And get them to answer that question and then ask the next one.
I came across this when I was dealing with solicitors' professional indemnity insurance, and this very same matter came up because the policyholder, firm of solicitors, had a particularly large claim against them because of a quirk in the successor practice rules. They haven't done anything wrong, but this claim was made against them, I think, for 2 million. And I advised the firm of solicitors to continue disclosing it because they had a very good explanation as to how it came about. And actually, they got more credibility by disclosing it and showing that they'd behaved responsibly rather than trying to conceal it.
That's exactly the point. Just be upfront and be honest and open. Because if you've got a good reason, most underwriters will say, oh, okay then, that's fine, thanks for telling me. But not telling somebody something makes it look as though you've got something to hide, and that's never good in this game.
Okay, thank you very much. I think, Roger and Michael, if we take one more question, we have an awful lot of questions come through, but these will all be sent to Roger and Michael after the webinar, so they will endeavour to get through these and get back to you with answers. But let's take one more so we're not holding up too much of anybody's time. Okay, so Roger and Michael, could a justified non-disclosure be if the insurer is asking an illegal question, such as asking about spent convictions or for irrelevant sensitive data? So it is justified in not answering as the question is prohibited by law.
That's going to take more than 2 minutes.
Well, you can take as long as you need on this.
I think spent convictions is fairly straightforward. You are under no obligation to disclose a spent conviction, and if you do disclose a spent conviction, the underwriter has to disregard it. So actually, that's not a non-disclosure at all. I'm just struggling to think what the other example might be. What was the other example?
I think this is the point. We need examples, but it's a very good, it's a well thought out question. And it's the kind of thing that we need to debate and have a community agreement on how we see it. So we're achieving our objective just by getting the questions.
Okay, so hopefully some of these people who've asked these questions will ultimately come on and join your forum then that you're going to be setting up, and you can delve into this in a little bit more detail.
Yeah.
But in the meantime, thank you very much. Huge thanks to you again, Roger and Michael, for delivering yet another really excellent and informative webinar. Just a reminder for delegates that you will now be able to download your CPD certificate and also the fact sheet that has been created by Flaxman's in association with the CII. That will be available for you too. And finally, just to say thank you very much for everyone taking the time to join us today. And hopefully you continue to enjoy the CPD that is being delivered to you from Flaxman's and the CII as well. Thank you very much.
Okay. Thank you all. Thank you very much. Bye-bye.